Welcome back to Autism Live. We had told you we started an interview with Bonnie Yates earlier in the show, and we wanted to continue on the conversation. So you found us. We're here with special education attorney Bonnie Yates. She was talking with us about getting ready for the IEP process. Thank you, Bonnie, for being willing to stay with us and continue to talk about that. Since some of our viewers will be catching this at a different time, I want to remind everybody that you're joining us from the law firm of Hirji and Chow. Tell them where they can get a hold of Hirji and Chow if they would like to find out more and potentially do an intake.
You can just give us a call at 310-391-0330 and we'll set you up, okay?
And I think it's worthwhile for you to do the disclaimer again, Bonnie, and then you can go ahead and pick it up where we left off, talking about IEPs and knowing what your rights are.
Great. Okay, so the disclaimer is the advice being given today is general in nature, so if you have a specific problem, you should consult with an attorney in your home state. I'm licensed to practice in California and before the federal courts in all 50 states, so it's under those laws that I give my advice. And so if you're from another state, you need to talk to an attorney in your own state. Where we left off was kind of about setting the proper tone at the IEP meeting and how IDEA has this really coercive leveraging aspect whereby the parent attorney can get the school district to reimburse attorney's fees, and that's really what motivates districts to work hard at mediation and to settle the case. So obviously, if there's no coercive leverage in the form of attorney's fees being a possible outcome, they're going to be more likely to just kind of continue stringing parents along, particularly if there's no timelines that are running, because at the IEP level, there really aren't any, except for that there has to be an IEP once annually, and there has to be a triennial evaluation once every 3 years. When you file for due process, that does start a clock running, and so all of a sudden the districts do have to pay attention. But we're at the IEP level right now, and in terms of your moving around in that environment, something that happens a lot, I find, like you come into the meeting and you're on time and you need to get your documents out and you need to get your audio recording equipment out, and they're like, let's start. And you need to just very calmly say, I need a minute, I need to get my things out, I need to set up my recording device. And you shouldn't let them intimidate you or rush you. Parents are equal members of the team. Their participation is viewed as, and their input is viewed as very important. And you want to be able to, collect yourself as best you can and, have your thoughts at your disposal. So don't let them rush you. Another thing is that a lot of the time they will be reading from something and you'll be thinking like, what are they talking about? And then you'll ask them, well, what are you reading from? And they'll be reading from a draft IEP document. They'll be reading proposed goals. So you should always say, well, let's stop now. I want a copy of that document. And, similarly, if they're reviewing an assessment, you should have a copy of the assessment in front of you. And I've also said, and I think it's important that one of the things about you might want, progress reports, progress on goals. I mean, there's any number of things you might want to see. You should ask for them, and you shouldn't feel shy about asking. The other thing is, I've had a situation come up a couple times in a meeting where somebody circulated a reference or something important was being discussed, and I thought I might not have access to it later on, like a student work sample that I was afraid it was going to disappear. So the genius of the camera phone is you can just take your phone in that meeting, and if you're afraid a document's going to disappear or a reference is going to become unavailable, just take a picture of it. They can't prevent you from doing that. Anyway, I've arrived at a way that I do my meetings now, and I don't know whether parents necessarily need to do it this way, but I'll just present it to you. I've kind of, gotten with the program in old age, and everything is all electronic. So I have all your documents scanned into my computer. I have access to them at the meeting, and I also take notes on the computer. I bring in my laptop, I set it up. Most of the time I have access to the internet, which my particular program requires, with certain districts who shall remain nameless, but they're the largest district in Southern California, their internet never works. So I just take notes on a Word document and I'll dump it into my program later. But I find that it's a lot easier for me if I have, access to the child's whole file online, and if I take my notes in written form so I can review them later. I wanted to mention that sometimes that same certain district that's the largest district in Southern California but will remain nameless says that they can't write certain things into the IEP because their computer program will not allow them to do that. You have to tell them that IDEA does not require that something be left out of the IEP because some computer program doesn't let them write it in. I mean, the IEP is not a self-driving car, okay? It's something which there's a manner in which it's supposed to be done in order to offer the student FAPE, and there can't be any topic that's off limits and can't be documented because they don't have the box in their form. So hopefully we aren't dealing with any of that. I will have out on the table any documents I need to refer to. So that's usually going to be past assessments and past goals, because progress is going to be based on goal progress. And if there isn't progress from last year to this year, that's going to mean that the IEP didn't offer FAPE. But it's very hard to tell if the goal progress has been met unless you can look at last year's baseline and compare where the student was then to where the student is in the present. I have this cute little joke that I tell that's mainly for my own amusement, but I tell people you can never be partially pregnant. So when I get to an IEP and they start telling me that John partially met all of his goals, I trot that out because you either met the goal or you didn't in a year's time. And partially met also means partially unmet. So what I like to do is I like to calculate how many of the goals have been met, and then at the end I will say something like, okay, there were 15 goals, he only met 4 of them. That's not a very good track record. It's obvious that the IEP, as implemented, isn't resulting in him receiving a FAPE, so there's something wrong here, and we have to do something about that. So that's why it's very important to track goal progress in the IEP meeting. One thing I meant to say you can do before the IEP, which is interesting, is you can find out how litigious your district is. You can go online to the California Department of Education website, plug in your district name, and see how many times they've gone to hearing in the last 10 years. And you can kind of see who the players are, including potentially their attorney and everything else. And while that won't tell you how many filings there are in a particular district, it will tell you how often the district has gone to hearing and under what circumstances. And you can distinguish between like full-blown cases with really, multiple issues versus a situation where the district is merely fighting with the parent about the right to assess or something. And sometimes what you see in districts is that they don't go to hearing much except for when the parent is unrepresented. And those for them are like shooting fish in a barrel. They know they have the advantage, so they may take those on.
There was a statistic, Bonnie, that was going around for a while that there had been no cases won by an unrepresented parent in and then the number of years would change.
Yeah.
And is that fairly accurate, or is that just a myth that's out there? It's really rare.
Statistic, but I think that parents that are unrepresented will lose. There's a great article by a guy named Jed Rakoff, who's a trial judge in the New York Times Review of Books that I read a couple months ago. And what he talks about is how little access there really is to justice in the United States, how many people have to represent themselves, whether it's in civil litigation or small claims court or wherever it is. And then he shows how much worse people do when they're not represented by an attorney. So it's interesting.
Yeah.
And I think that, people think that IDEA is, child's play or something because it just involves kids, but it's a serious litigation, just as serious as any other kind of, adult subject matter. And in the cases where the district's taking it seriously, they have a lawyer, and you should have a lawyer too, basically.
And so to be clear about it, what do you think about is it necessary for parents going into just the IEP before they know what's happening? Is it necessary to take a lawyer if there aren't any huge red flags? Or is that the kind of thing that you wait for the lawyer until you see, oh, we're going to have to go to due process? What do you feel about that?
Well, that's the very question that one has to ask is, what happens. There's clearly some situations in which if the parent is prepped by the lawyer as to how to set up the meeting, if the parent goes in unrepresented, the district's probably not going to behave as carefully, and they may make tactical mistakes that are very damaging for them. There's other situations where you really want to hold their feet to the fire from the start. Every situation requires, I think, a specific analysis of at what point one should send a lawyer in. If you're in a good holding pattern, the way you've been, Shannon, over the years, I don't want to personalize it too much, but you managed to make your IEP meetings work without an attorney. It's really going to be case specific, but if you have big stuff that you want or you need big changes, that's just not going to happen without an attorney.
Well, and I got to be fair too, Bonnie. I always had good advice from you going in. In fact, that's how I met you, was that a family, when we saw that we were going to have a problem the first time out the gate, a family said to us, oh, you got to get Bonnie Yates. We came to your law firm and we did the initial half hour. I got great advice, went back in and was able to make things work just with that half hour's worth of advice. I think, you've been instrumental to me many times, and then we became friends as a course of things. But, honestly, I would be remiss if I made it sound like I was just able to go and do the IEPs all by myself. That's not incredibly accurate. I had good Bonnie Yates help.
Well, as you see from this discussion, there are very specific rules that apply here. How is a parent supposed to know? How is a parent supposed to know whether or not they can ask for an evaluation? How is a parent supposed to know whether or not they can ask for a particular type of goal? It was supposed to be set up as a system that was informal, that was streamlined and efficient, and parents could negotiate it on their own. It hasn't turned out that way.
Yeah.
So there's not any one hard and fast rule about when to get a lawyer involved. But just, yesterday I had a conversation with somebody. She's a teacher. She is preparing for her daughter, who's a special ed student, to go into 7th grade. And we discussed whether or not she should have an attorney come to the meeting, and we decided that she shouldn't. We decided that what she should do first is try to sort of praise up the new IEP team that's going to be taking over in middle school, and tell them how great things have worked at the elementary school level and what things that the teachers did, and see if we can get them to sign on for the project rather than resist the project. Because, once you get into litigation with the district, it's going to be very hard for teachers to feel good about things if you're in litigation.
Yeah.
And I think that's what parents worry about. They worry about how the district's going to treat their child once the family's filed for due process, and that is a relevant consideration.
Yeah, and it's all stressful. It's stressful on the family, and I think it is stressful on the teaching staff while you're going through it. It is stressful, but sometimes it's what you have to do, or you waste a year, and nobody has time to do that.
Exactly, and that's why we recommend that you get legal advice. And there's really not any impediment to people getting legal advice, because a lot of firms, ours included, will consult with parents without charging them. So to me, it's like when we do an intake for someone, and we do them all the time, whether they use us or not, we feel like we've kind of furthered the mandate of IDEA, which is to educate parents about their children, because, or their children's legal rights, because they're obviously, the most concerned people. They spend the most time with their children and know them the best. And so, it behooves them to learn as much about this process as they can.
Absolutely.
There's also a lot of stuff on the internet now, and I'm not saying it's all legally perfect, but there's really a lot of information available. And I think most of the time it's not dangerous. It's like good stuff to give you, just more tools for dealing with a process that's gotten very formal and complicated, and there's lots of personalities and egos and so on. So let's see. So something else I'm looking for when I look at an IEP is whether the district made the child eligible timely, or whether there was a time period where the child should have been made eligible where they weren't. And that's called child find. And believe it or not, we do have some cases in this day and age where somebody is not eligible under autism, and they should be. What else did I want to talk to you about? Okay, so districts always want to excuse teachers, like the general ed teacher from the meeting. And whether or not that's a good idea really depends on what kind of help you need from that person. If it's the general ed teacher and you need him or her to write goals, they pretty much have to be in the meeting. If you think you can excuse them because their participation may not be necessary, I try to get a cell phone and a commitment out of them that they'll be available if we call them at that number. So don't sign an excusal form because you feel pressured unless you're really pretty sure that you can let that person go. So as we said, there's an order. The first issue was eligibility. Once you look at eligibility through the assessments, then you can start developing the goals and objectives based on the unique needs that the assessments revealed. I think we said that they only have to reevaluate every 3 years, but they changed the law within the last, 5 or 8 years, and they said that the parent can waive all or part of the triennial evaluation if they want to, but I really recommend against that. I think that's a bad idea. So I think you should insist on the full evaluation. Because remember, if they make mistakes on the full evaluation, then you're going to be able to get your own evaluation. We can talk a little about the eligibility categories. I wanted to say that ADHD in and of itself is not an eligibility category, but what ADHD may trigger is the possibility of being eligible under other health impaired. Other health impaired is a catch-all category. But if your ADHD causes you to have diminished alertness, strength, and vitality, that's the language, as the school day progresses, then you're probably going to be made eligible under other health impaired. Otherwise, you're only going to have a 504 plan. And we've discussed earlier in other sections of sessions of our discussion that 504 plans are really not that helpful for people. A district assessment can be attacked for up to 2 years afterwards. So if you have an assessment that's 2 years old or younger, you can use that as a basis for requesting an independent educational evaluation at public expense. Now, some districts don't use a secondary eligibility. They just have one eligibility. Some have two. Eligibility in and of itself does not determine what services you get. So in theory, if you had a child who was eligible under other health impaired rather than autism, but the district gave him a 40-hour-a-week behavioral classroom or something that was, highly engineered to meet his needs, the fact of that wrong eligibility would not really be a problem for the district. But what we tend to think is that, somebody that has an autism eligibility is going to get more intensive services. And so usually if the district has missed the autism eligibility, we're going to argue that that led to constructing an IEP that wasn't reasonably calculated to lead to educational benefit. We talked about baselines and why they're important to measure progress, and why you want to watch out for sort of the partially mets. Baselines are also referred to as present levels of performance, or as we call them, plops. And so you're going to be looking at, progress on past goals and how the student did. And if the prior goals aren't measurable, I'm going to give the district a really hard time about that, because if they aren't measurable, how can I tell if the student made progress? Similarly, when the district's writing goals for the next year, which is how long we write goals for, I'm going to force them to make the goals be very measurable, because I don't want to be in a situation a year from now where they can sort of do anything they want to and say the goals are met. My standard is pretty much one of, if you had to take the IEP out of the district, nobody knew the kid, and none of the teachers that had been working with him were working with him now, would this new person be able to understand the goals and what they were supposed to do and how they were supposed to be measured, or not? So that's really the standard. Now, if you have a situation where the district is using the same goals over and over again from year to year, that is an obvious indicator of the fact that the person is not making progress from year to year. So you want to watch for that as well. So there's a question as to whether the student will participate in statewide assessments or not. You get to that part of the meeting. And, for a person that's in elementary school, I basically think that stuff is a waste of time often. Some parents want their children to have test-taking practice, so that's fine. They can take the statewide assessments or whatever they are with accommodations. There's also going to be a question as to whether the student is graduating on a diploma track or with a certificate of completion. California got rid of the high school exit exam in the last couple of years. I mean, I think they suspended it till 2018, but let's see if it comes crashing back or not. What I'm seeing is a lot of graduating of people from high school, which ends their IDEA entitlement, and they can only read in the fourth grade, at the fourth grade level. They can only do math at the third grade level. They're clearly not going to be able to compete in the marketplace with those kind of skills. And so we really need to look very carefully at those, issues, the question of whether or not you're going to be on a diploma track, and if you are, how you're going to make sure the district doesn't graduate you before you're really ready. When I look at somebody's IEP, like a poor person, I hate to say it, but poor people are, oftentimes have the quote-unquote best IEPs, which means the worst IEPs, because the district thinks that they're never going to come back and make an issue of what was done. So, sometimes we'll have an IEP for a child with autism. They will only have, let's say, 2 goals. So, you want to ask why the district wants to avoid writing goals. Well, the answer is, if there aren't goals, there's not any accountability. Oftentimes they'll tell you, well, this is part of the common curriculum and the teacher is responsible for working on it in the classroom. Don't buy into that. If there's not a goal, there's not going to be any requirement that they be accountable in that area. When I get records from a parent that's really on top of it, what I will usually get is a lot of correspondence between the parent and the teacher, a lot of work samples, a lot of very relevant information. And when I get the students' records from the district, that stuff is almost always missing. Now, I don't know where it goes. I didn't realize it was printed on, dissolving paper or something. But it's really important for parents to save everything, because you never know what you're going to need. It's also really important that you rid yourself of the temptation to use the phone and stop talking to people on the phone, because when you have a telephone conversation, it's as if it never happened. And email's really easy, so you should just be documenting everything in email these days. When the goals are being written, you need to look also for things like, okay, if they're going to use prompts, are they verbal or visual, and how many are they going to use? And they're not allowed to use up tos, whether that means up to 3 verbal prompts or up to 2 hours a week of services. It has to be specific. It can't be loosey-goosey like that. make sure that the goal is adequate to occupy the student for a year. And if you have goals that you want the district to write in a certain area, you have to be prepared to go in there and factually explain why it's an area of need. So that's something about goal writing. Lately, I've seen districts doing this kind of parent is responsible, student is responsible for goal progress, and that's just wrong. No one is responsible for goal progress except for school officials. Now, the goals drive services and placement. So now we're kind of getting to the part of the IEP that everybody's been waiting for, which is to talk about the services. And services need to be specifically delineated in an IEP. And you need to watch out if the services are not specified as individual in nature. In other words, if something isn't specified as individual, assume it's group. And if it is group, get somebody to specify, is it a group of 2? Is it a group of 3? Is it a group of 200? You need to understand what that really looks like. And it's your entitlement and your job to advocate for whatever placement and services you think are appropriate. And don't let somebody, shame you, make you feel small, make you feel silly or wrong for advocating for something that you think is important for your child. That's exactly what the drafters of IDEA had in mind. And when you're talking about placement and services, the district has to have somebody at an IEP meeting that has the authority to offer the placement that the parent requests if the team decides it's appropriate. So there has to be somebody there with decision-making authority, and there sometimes isn't. Sometimes they'll say things like, yeah, I'd love to do this, but I can't, and I can't get a hold of my supervisor. That's a denial of parental participation. You're supposed to have an opportunity at the meeting to present what you need to somebody that actually has the power to make it happen. Now, at the IEP meeting, they're going to talk about what's called the continuum of options, and this is tied in directly with least restrictive environment. And so the district has the ability to offer the least restrictive setting, which would be a general ed classroom with or without support, and the most restrictive setting, which would be either, home hospital teaching or a residential 24/7 educational facility. And so what is least restrictive is going to depend upon the child's needs. And I think one always wants to start with the presumption that inclusion is the best placement, and then work from there and see whether, it could be inclusion with appropriate ABA support, or it could be a partial inclusion with some time in special ed class, but lots of mainstreaming. So when students become 16 years of age, there has to be something in place called an ITP, which is basically an outcome-oriented document that promotes their post-secondary goals. And that's supposed to prepare them for the shift to vocational education and ultimately adult employment. And so when your child reaches this age, you'll start to have something called I'm just telling somebody else to come in here and get coffee. So this is Rosa Hirji, the managing partner. It's good for you to have an opportunity to know about these.
Hello.
She works so hard, she gets thirsty. Anyway, ITPs don't seem to be something that's subject to very rigid scrutiny under California law, and they basically are very limited in terms of what will be in the document. Usually it indicates that it was done by an interview with a student, and it'll talk about, where the student is going to go post-graduation and what kind of supports he or she needs. They're basically templates. They're totally useless. I think we should be challenging them and trying to make the law stronger. They don't help the student at all, but that's what an ITP is. Extended school year and transportation are sometimes not addressed by the IEP team. Make sure those are considered because they're always going to be relevant. For students that have a physical disability, they may need a specialized physical health care plan. And if your child has, diabetes or a complex metabolic syndrome or some other condition that requires supervision of a nurse, they should have, as part of the IEP, a specialized physical health care plan. Now, once we get to the end of the IEP, whether there's a dispute or not, the district is going to create a written document. And sometimes they'll give it to you right at the end of the meeting, but more often than not, they ask if they can get it to you afterwards. And I'm sort of of the school thought that's like, yeah, you can get it to me afterwards, because I've been listening for about 3 hours and I'm pretty tired and I'm not inclined to review this document on the spot and sign it anyway. But I think there's a disadvantage in doing things that way, which is that if you get the notes and the notes are inaccurate, the best time to correct the notes is right there on the spot. And so make sure that you understand that you have a right to correct the notes and that you do correct the notes and you do so as quickly as possible, because if you get an IEP after the fact that's 2 years old, you're obviously not going to be given the option of going in and correcting the notes at that point. We know that the IEP team has to make a specific written offer of placement by the end of that meeting. And it can't just be a special ed class at Monroe High School. It really needs to, you need to be able to know specifically, so you can ask questions about the placement from somebody that's knowledgeable. You can make an opportunity to visit the placement later, and so on. Certain districts, rather than giving you a placement that's specific, will give you a general placement. That placement, that district I was telling you about, that's the largest district in Southern California, has a habit of giving parents a letter after the meeting, and on the letter is what we call a shopping list. It'll be 3 or 4 different placements the parent is supposed to look at and figure out whether or not he or she thinks that's an appropriate placement. That's a completely illegal placement offer, as it's not made at the IEP, and the parent has no real ability to ask questions of the IEP team members. So be on the lookout for that. Let's see, where are we? So there's a lot of information in your parent rights that you're given at the beginning of the meeting. No one, including the lawyers, ever read those, but I've started reading them lately, and they're fascinating because they really do tell you a lot about the process. And if after the fact you claim that you were not informed about something, whatever it was that you were not informed about is in the parent rights, then I don't think you're going to be able to raise that as an issue after the fact. So we talked about, you have the right to obtain your educational records. The district has 5 business days to do that. We talked about how important parental participation is in the IEP process. We talked about assessments and independent educational evaluations. We talked a little bit about timelines. Now, in California, you don't have to consent to all parts of the IEP to have some parts be implemented. You can provide a written consent after the fact that's a partial consent. And the district has a choice. They can either agree to implement the things that you agree to, or if they think it's impossible to offer the student a FAPE without those other things, then they can file and take you to hearing. The right of statehood is a very important right that parents have, and we didn't talk about that at all. But fundamentally what it means is that if a dispute arises at an IEP meeting, the parent has the right to invoke statehood, and his or her child can remain in the last agreed upon placement until the dispute is resolved. And it's unclear whether, in your particular district, they will agree to stay put just because you invoke it at the IEP meeting, or whether you're actually going to have to file for due process. But once you file for due process, that will give rise to an automatic injunction of maintaining the status quo placement. And that would continue all through the pendency of hearing, during the hearing, after the hearing if you lose an appeal, and so on. So stay put ends up being a very important right for students because it does give them some degree of control over what happens if there's a disagreement about placement. Now, once the IEP is over, the parent can address disagreements about the IEP in several ways. One is a compliance complaint to the state of California. Another is requesting alternative or informal dispute resolution through the district. And then the final is due process. There are certain problems with state complaints. One of them is that they will only investigate if you aren't simultaneously pursuing due process. Another is, in my opinion, a lot of the compliance investigators are pretty burned out and I think tend to side with school districts more than they should, but that's, my opinion. Maybe not everybody agrees with that. The problem I tend to see in alternative dispute resolution where parents go and they're unrepresented is the district knows what their claims are worth, the parent doesn't. And it's really sad to see a parent waive, 2 years of claims for, let's say, a private evaluation when they could have gotten that evaluation by way of an IEE, and now they have nothing left to litigate. So, I'd say be careful with that. Now, there's a whole other program, Shannon, that we can do next, which is more specifically about due process, but I'm thinking that we're at a good stopping point for today in terms of the IEP meeting.
Wonderful. I think this is all really useful information, Bonnie, for people who are going through the IEP season right now, to put you in a place where you're empowered, know your rights, know what may happen and how you can handle the different things. This has been amazing. We want to remind people that you are an amazing special education attorney yourself with the law firm of Hirji and Chow, and give them the phone number of how they can reach Hirji and Chow if you would.
Certainly. The phone number is 310-391-0330, and we look forward to your continued comments because they're an important part of the show.
Absolutely.
So thank you for that.
Thank you, Bonnie, for being with us. We hope you have a great weekend, and we can't wait to be with you again next week.
Thank you, Shannon.
All right, take care.